Hello friends, good afternoon and welcome to the EduSat network. Our topic of discussion today will be the philosophy of the Indian Constitution, and to talk about this topic we have in our studio subject expert Dr. Satish Kumar Jha, Associate Professor, Department of Political Science, Aryabhatta College, University of Delhi. With this brief introduction, I welcome sir to the studio. So thank you so much for coming, and I also request you to begin the lecture.
Thank you, Dr. Urvasi. Today's discussion we are going to have on philosophy of the Indian Constitution, and both word the philosophy and the Constitution are basically symbolic of something which is highly ideological in nature, because Constitution as it is normally understood, that is basically a document of laws, rules and different provisions governing the society, but it is not simply that. Constitution is much more than simply a document of laws, because what Constitution reflects essentially is basically the societal consensus on number of issues, and at the same time Constitution also reflects the philosophical moorings of the society. Of course, philosophy of the society, when we use the term philosophy of the society, what we mean by that it connotes large number of cultural, traditional, social, economic as well as many other dimensions which get telescoped into this document that is called Constitution. When we come to India, the philosophy of Indian Constitution, we have to take into account 3-4 important factors. That first of all, you have one text called Constitution of India, and on basis of that text one can find out that what is philosophy underlying basically this entire structure. But at the same time one also has to take into account the long struggle which Indian people waged against the colonial rule, and during that struggle there were certain values for which the Indian people fought together, and those values were so dear, so cherished that what happened, that when they got the opportunity to frame the Constitution for themselves, they tried to basically make a space for all those values. But that was not the end of the matter. What happened, that Constitution didn't emerge in a vacuum, but Constitution also brought within its purview the large number of issues which were there in part of Indian social process, which basically had evolved over the ages, and therefore history has informed this entire discourse which is basically available in the Constitution of India. So thereby what we find, that history of long history of Indian people, Indian society, as well as the struggle, that is a freedom struggle, along with the deliberations which took place in the Constituent Assembly, these three things have played important role in giving the philosophy to this Constitution. But there is no agreement among scholars that how to basically deconstruct this philosophy, how to basically figure out the philosophy underlying the Constitution. One way to do is it is to simply look at the text of the Constitution, that what are the various provisions in the Constitution, what do they reflect, and there are many values which are there, and therefore one can simply go by looking at those values, those principles, the political principles and other principles in the Constitution, and thereby one can arrive at a conclusion that this is basically something which can be called the philosophy. But at the same time one should also bear in mind that there are different provisions, there are different principles, political principles in the Constitution, but those principles are matter of interpretation. They are highly contested principles, they are highly contested basically issues and values. For example, even if we look at the preamble, which is considered to be the important source to understand the philosophy of the Constitution, even the three important words which occur there, and those three important words have been subject of heated exchange among scholars so far as this philosophy is concerned. For example, issue like secularism, issue like socialism, issue like republicanism, all these words figure there, and all of them have been contested, have been questioned, have been debated. It is true that two words, that is secularism and socialism, were not part of the original text of the constitution, they were inserted later through 42nd amendment. But nonetheless, there are many principles in the constitution who basically in one way or other tell you about these values, tell you about these ideologies, and therefore, what preamble has done by inserting them, that only it has basically made it more definitive, it has made it more clearer. But nonetheless, it is a matter of debate, it is a matter of discussion among scholars, that what is the nature of Indian secularism, what is the nature of Indian socialism. Even the word democracy, in fact, the entire Indian political system is basically known for its democratic features and democratic credentials, but nonetheless, even democracy does not have one meaning, but it has number of meanings, it has number of connotations. In what sense India basically has gone for this democracy, that is also something which we should understand and we should basically try to figure out. Now, what happened that of course, in modern times this democracy has taken a particular form, that is indirect representative democracy. Even in the Constituent Assembly there are many voices which were basically in favor of making provision for direct people's participation, or at least some instruments through which people could be empowered, or at least some direct participation could be secured. But it was not entertained, rather it was turned down. Now, in recent years what we are finding, that there is a growing clamor for this direct democracy, even if it is not direct democracy in the classical sense, but then certain mechanisms, certain methods, certain procedures through which you have less reliance on representation and more participation of the people. But it is still a contested thing, because a lot of people feel that a society like India, or even in any modern society, it is not feasible, it is not practicable, and therefore it is also not desirable to think in terms of anything called a direct participation of the people, at least at different levels of political sphere. So therefore, what basically I am trying to tell you here, that all these issues, whether democracy, secularism or socialism, they are the important philosophical features of philosophical moorings of Indian constitution, but nonetheless there is no clarity that in what sense this was talked of. For example, when the Constituent Assembly was debating all these issues, what basically at that time was known as objective resolution, that what would be the objectives of this constitution, and none other than India's first Prime Minister Nehru moved this objective resolution in 1946 itself, after this Constituent Assembly met sometimes in December. Now, what happened, that when the debate started on his objective resolution, many members, honorable members pointed out that this term democracy was missing from this document. And if India was really aspiring for a democratic order, then how come this important word is missing from this document? And the defense of Nehru was quite interesting. He said that of course this democracy does figure in this objective resolution, but that doesn't mean that India has any has any dot on democratic principles, or India has any reservation on democratic principle. Rather, the essence of this entire document is democratic, and therefore this term is not required at all. Similarly, even there were attempts to bring in this concept of this term secularism in the text of the constitution. None other than K.T. Shah, a very eminent member of the Constituent Assembly, basically had proposed, but even that was turned down, that secularism was not basically required as a term in the constitution, because various principles of the constitution are secular in nature, and that would be enough to make this polity secular. So similarly, one question of socialism came up, that why can't we have a word like socialism, because equality is basically one of our mission, justice is one of the goals, and therefore if both things are there, then what is the harm in including this term socialism in the text of the constitution? And none other than Ambedkar said that constitution is basically a political statement. Constitution doesn't basically recommend the form of or the type of society which will be created, or kind of economic system which will be created, and therefore there shouldn't be much insistence on basically inserting this term socialism in the constitution. So what I am trying to basically point out here, that these issues were debated, these issues were basically brought to the notice of the Constituent Assembly, but still they were not entertained, and there must have been some reasons for that. And the reasons were that there was no consensus on these things. Basically, consensus always eluded most of the things, but nonetheless a workable consensus was sought to be created. But on these words, even the workable consensus was very difficult to basically evolve. For example, now we know through number of speeches and presentations in the Constituent Assembly and its various committees, that secularism there was a genuine problem because of the integration of states, princely states. Many princely states had a essential association or linkage with religion, and therefore it was not possible to integrate them if the secularism was there right from the beginning. That could have basically put them off. And similarly, there was a problem with republicanism also, because these princely states who were integrating with India had many reservations, had many conditionalities. So therefore, I think this Constituent Assembly, when it debated its objective resolution, which later on subsequently when Constitution was enforced became the preamble of the Constitution, this objective resolution had a limitation, because it was not possible for it to basically include all those things which were very dear to the members, or which basically India's freedom movement also upheld. Or for example, there was a societal consensus, but then basically some political expediencies required that those things were put on hold, and they were definitely put on hold. So therefore, what we find that this philosophy of the Constitution still we have to figure out on basis of 2-3 things. Number 1, the text of the Constitution. Number 2, India's freedom movement, and number 3, the history of the country. The 3 things can give us some idea that how this philosophy is available in this text called Constitution of India. Now, before I come to this text, that is the Constitution of India, particularly its preamble, which at one stage was objective resolution, and later on it became the preamble of the Constitution, we have to keep in mind 2 things: the history and basically India's freedom movement. Freedom movement, of course, is a part of history, but I am specifically mentioning freedom movement because many issues which basically cropped up during this discussion of the Constituent Assembly were those issues for which India's freedom movement specifically was fighting for, or some of the issues which they had promised to the people. It was their duty to basically bring them in this text of the Constitution, whether it is fundamental rights, whether it is federalism, whether you have this separation of power or universal adult franchise. These were the commitments at different stages in the life of India's struggle for freedom. For example, 1931, Karachi session of the Congress was quite significant, because what happened that in Karachi, number 1, the entire fundamental charter on fundamental rights basically got crystallized. In fact, what happened in Karachi that even the secularism as a principle had its beginning. Now, even before Karachi session of 1931, we have had this Nehru Committee 1928, very important committee, because this was the time when Indian people took up this challenge which was thrown by the colonial masters, that India, number 1, would not be able to evolve a consensus on, a broad consensus on the form of government or a constitution for themselves, and number 2, Indians were not capable to draft it. Now, what happened that the Indian National Congress and many other factions of the Indian national movement, they took up this challenge and tried to prove that they were not only capable of drafting this constitution, but they were also capable of evolving a consensus. And therefore, what we find that for the first time, first instance rather, when Muslim League and Congress, they came together and basically they tried to draft this constitution. It is a different matter that this entire initiative did not work, and basically the Muslim League and the Congress also parted company. All parties conference had basically created this committee under Motilal Nehru committee, and that's why it is known as Nehru committee, Subhash Chandra Bose as secretary. And therefore, what happened, there are a number of contentious issues like the nature of Indian federalism, whether residuary powers would be with the provinces or the center, whether the provinces would be provinces will have autonomy or not. So, all these issues, even reservation, that what will be the nature of reservation in Muslim majority provinces, because it was already agreed that there will be reservation for minorities, particularly Muslims in Muslim minority provinces. So, these were the contentious issues on which no agreement could evolve. Even on federalism, which is a dominant basically philosophy or ideology of the constitution today, even on that federalism no consensus could arrive. And therefore, what happened unfortunately, that federalism at that time was interpreted as in communal terms, because Muslim League was using federal argument to justify their political position. And for them, of course, the federalism had a different meaning, because what happened, they wanted autonomy for provincial units. Particularly for them, it implied that those provinces where Muslims were in majority, they could enjoy autonomy, and therefore, they would have full control on the state power. So, therefore, even without having partition, they wanted some major say in the governance by having a control on the state administration. Therefore, the Congress always looked at federal demand with skepticism, and therefore, one of the reasons that when Subhash Chandra Bose and Gandhi fell out on the issue of presidential election and the way Congress should conduct itself, I think one of the attack on Subhash Chandra Bose was that basically one of the defense of Nehru against Subhash was that Subhash Chandra Bose was believing or calling all those who were basically not subscribing to his position as federalists, whereas Nehru believed that they were not federalists. So, basically federalism at that time had a pejorative connotation because of largely the Muslim League Congress politics. But even but now after independence, we find that federalism perhaps one of the most cherished goals, because every political party feels that federalism is the future of India. Now, a vibrant federal polity can protect the interest of the people. So, with time, of course, things have changed, but therefore, what we have to keep in mind that how they have changed, where from it started and how it started, what was the philosophy behind it, because federalism of course also had a philosophy. The federalism, of course, as we know, evolved in United States of America, particularly since then it has been adopted by number of countries, particularly those countries where social structure is quite complex, where challenges are basically multiple, which are basically plural in nature, multicultural in nature, and federalism, it is considered that one of the most effective and the best mechanism through which such challenges could be met. So, therefore, India also in line with this thinking went for a federal polity, but of course, as it is normally believed that United States of America is the ideal model. Any country which deviates from United States of America is either dubbed not federal or basically semi-federal or quasi-federal, whatever. But the thing of the matter is that federalism is a mechanism which is basically there to deal with those problems, societal problems. Every society has its own problem. India is no exception. Therefore, if India has deviated from United States of America, there are valid reasons for it, and those reasons were largely political, administrative, and number of other reasons. Therefore, what should be kept in mind that federalism is a dynamic concept, it is not a static concept. It changes with time, it changes with space, and therefore, what we find that no two federal polities in the world today are identical or similar in nature. There are differences, and those differences are quite common. The differences are largely on account of the fact that every society has its own problems. So, therefore, what we find that one of the philosophy of India's constitution at that time was how to keep this society together, how to keep this nation together. First of all, this nation itself was a contentious issue, because what happened, the Britishers always questioned the foundation of this nation, and there was a reason for that, because Britishers were familiar with the European experience, and the European experience said that for nationhood what is required is basically a common language. But India had not one language, but more than 3,000 languages, and therefore, the kind of diversity they found in India was mind-boggling for them, and they believed and they basically realized that it would not be possible for Indians to weld themselves into a nation, because nation ultimately has should have some elements of commonness which can unite them. But in India, they found that there was nothing which could unite them, there was nothing which was in their there was nothing in common among them. So therefore, this nation was a contentious issue for them. Indians of course took it a challenge, like they took many challenges. As I mentioned that in 1928 they also took up this challenge, that how could they frame the constitution for Indians. So I mean, this nation in making, as it was commonly argued and commonly looked at, this nation in making had to be made stronger, and this could be made only by sticking to or adhering to certain ideologies or adhering to certain philosophies. Of course, ideology is little bit contentious compared to philosophy, because when we say ideology, that tells you that ideology means that there are certain fixed ideas. The ideology means closeness, that some dispute, some differences, there is some element of biases and prejudices. But philosophy, when we mention philosophy, then we feel that basically it is free from the biases and prejudices. There is some amount of universality in it. There is some amount of commonality in this. So therefore, instead of using the term ideology, people use the term philosophy of the constitution, because the moment you say ideology of the constitution, it can also be assumed that many people may disagree with that ideology. But the moment you say the constitution, then constitution basically reflects the societal consensus, of course at a particular point in time in history. For example, when you say Indian constitution reflects the societal consensus at the time when it was being framed. Of course, that is why later on that consensus also keeps breaking down. Therefore, what happens on number of issues, amendments are required, and amendments are basically the method through which the later generation, the amendments are the method through which subsequent changes are incorporated. Otherwise, it will become stale, otherwise it will become outdated, outmoded, because if there is no scope for any change in this constitution. So therefore, there is a difference between ideology and philosophy, and that is why we are using the term philosophy of the constitution, not ideology of the constitution. Now, what I am trying to basically argue out here, that this entire freedom movement therefore provides a very sound basis for the philosophical understanding of this constitution. And freedom movement of course was struggling against many odds. One of the odds was of course this disunity which was basically presented by Britishers as the reason for their presence in India, and that disunity had to be countered, and that disunity had to be basically tackled. And even the freedom nationalist leaders were not totally oblivious of this fact, that there were factors of disunity, that for example caste was a reality, communal differences were reality, whether we attribute it to the colonial rule or we attribute it to something else, but nonetheless they were reality. And therefore what happened, that nationalist leaders were basically aware of these things, and they wanted to tide over those crises. And how to do it? Only by basically devising means and ways through which such factors of disunity could be minimized, or could be basically tamed, or could be controlled. So therefore, it was a very important issue that in the future constitution of India, how such mechanisms, how such instruments could be devised, how such instruments could be accommodated. So therefore, the constitution making was not an easy job. Constitution making is not an easy job in any country, not only in India, because constitution and democracy, they have a very adversarial relationship. Though it appears quite odd that why constitutions should have adversarial relationship with the democracy, but fact of the matter is that constitution puts a brake on democracy. Basically, it is a kind of control, the constraint on the democracy. If democracy means raw power, then only through this constraint of constitution that raw power is turned into orderly strength of the people. Without basically without constitution, democracy would no longer be democracy, but it will become mobocracy. So therefore, one can use the metaphor of ocean or a sea, that when there is a tide in the ocean and the sea, then what happens, the tidal waves are so powerful that they can move and they can sweep away lot of things, because the potential energy is unleashed, and that potential energy could be devastating. But what happens, that constitution is like those small stones, those small obstacles, those hindrances, obstructions, which basically check that tidal wave, basically the potential energy of the tidal wave, and therefore basically turn that wave into something which basically becomes harmonious, gets harmonized with the people's lives. So therefore what happened, the constitution puts a check on this democratic wave, otherwise democracy could be devastating, could be destructive, could basically lead into anarchic situation. So therefore constitution and democracy have this type of relationship, even if it is a check, even if it is a constraint, but nonetheless without constitution democracy does not have much basically value. So democracy acquires value largely because of constitution. So therefore the relationship is also quite important and also quite significant. Now this constitutionalism, therefore, this entire principles which inform this idea of constitution, and this has evolved over the ages, of course in modern times, but of course it is also there that ancient people, ancient thinkers were not totally unaware about the significance of the constitution. So much so that Greek philosopher, Greek thinker Aristotle studied 158 constitutions to basically come to a conclusion that what is the best form for the people. But in modern times, of course, it has acquired a new form. And United States of America was perhaps the first example of a written constitution. But constitutionalism, one can say, evolved even before this written document came into existence. For example, the United Kingdom, of course the unwritten constitution, but surviving on the basis of conventions, on basis of usages, on basis of common law, on basis of traditions, have played a very important role in the evolution of constitutionalism. So is the French experiment, and later on, in fact in 20th century or in late 19th century, many Commonwealth countries like Australia, Canada, New Zealand, South Africa, India, these are the other examples which have added new dimensions, new value to this whole host of experiments which are known as constitutionalism. So what has happened, therefore, this constitutionalism and relationship between constitution and democracy are also, this relationship has to be seen in context of India, that how it basically got materialized and how it did two things. First of all, address the challenges of Indian society, and number two, it did not dilute the essential philosophy which basically was underpinning this entire struggle, that is freedom struggle. And therefore, when Ambedkar, who was the chairman of the drafting committee, when he piloted this draft bill on the floor of the Constituent Assembly, he said that one of the criticism of Indian this draft is that there is nothing new in this constitution. Everything is a copy of other countries, either USA, Britain, or for example 1935 Act of Government of India Act 1935, which was a British creation. So but he added that at so late in the day there could be nothing new, totally new in any constitution, not only this draft constitution, any constitution which is written so late in the day. But then what is the newness which can be added, and that newness can be added, that how existing things are molded, how existing things are harnessed, how existing things are used to suit a particular society. And that way Indian draft constitution, he said, that was an interesting document, was a novel document, was basically a new document which had tried to combine various features from various experiments and various polities, and has tried to come out with something different and something new. So this was the situation. Now what happened, therefore, that this freedom movement played important role so far as the philosophy of the constitution comes. But at the same time, if you look at the larger history of the people, then of course that history has also not basically has gone waste, because that has also influenced this entire framing of this constitution and thereby this philosophy in a big way. For example, two important things one can point out: this non-violence, the tremendous faith in non-violence of Indian society, and at the same time this tolerance, what gets translated today as secularism. Now, these two things, and then multicultural, in fact, or one can say plural. Of course, there is a difference between multicultural and plural, but Indian society was considered from the very beginning a plural society. So, these features have basically influenced this entire philosophy. But at the same time, this famous adage Vasudhaiva Kutumbakam, that entire world is one, like a family. Now, this fraternity, the universalism, the cosmopolitanism, these are the philosophical commitments which you find in the constitution, and they are coming straight away from Indian history. From the very beginning, this cosmopolitanism was one of the inherent characteristics of Indian people, Indian tradition, Indian culture, Indian society. So, therefore, even history has played important role. Now, coming to this text of the constitution, how to basically go about it. Now, there are three different ways. One way is to basically look at the salient features of the constitution. On basis of that, one can also discuss this philosophy of the constitution. Of course, what are the salient features? There are different salient features of the constitution. Of course, one of the most important feature is the basically elaborate discussion of fundamental rights, and along with the fundamental rights you have directive principles of a state policy. Then you have a system of government which is basically a parliamentary form of government. Then a form of constitution that is federal in nature. Then you have universal adult franchise. Then you have basically special provisions for minorities. Then there are special provisions for oppressed sections. So, these are the important features, and all of them in totality as well as in isolation tell you about the philosophy of the constitution. And what is this philosophy? What is this universal basically statement coming from this document? Now, we will basically take up all of them together separately, but to begin with, I will basically go by this preamble of the constitution, which comes at the very beginning of this text. That as I mentioned, that at one stage it was in form of objective resolution moved by Nehru in the Constituent Assembly in 1946 December, when the Constituent Assembly met in the first session. And during that session itself, there was a debate on this objective resolution. There were many positions, there were many presentations, there were many reservations, there were many endorsements, but nonetheless that set the tone for the subsequent discussions. And later on, when that was adopted, it became the preamble of the constitution. Now, the preamble starts with a very solemn commitment that we, the people of India, solemnly constitute India into secular, socialist, democratic, sovereign, secular, socialist, democratic republic. And all these words in themselves are basically conveying some meaning. Sovereign, that India is a sovereign. Now, a lot of debates have taken place that how India is sovereign, in what way it is sovereign, why this is to be stated, what is the requirement of stating it in so many words that it is sovereign. Now, there is a context of this, because India, when the Constituent Assembly was formed, of course, it was formed on basis of the Cabinet Mission resolution recommendation. And Cabinet Mission was, of course, the creation of British Empire, it was the creation of British Parliament, and therefore, it had put certain conditionalities. So, therefore, sometimes it is referred as transfer of power, that power was transferred, it was not revolution, there was no structural break. But one thing to be borne in mind, that what happened, that finally when this document called Constitution was ready for promulgation, who basically signed this document? Not the British monarch, it was not the British Parliament which adopted it. Of course, Constituent Assembly was formed by the Act of Parliament, but it was the President of the Constituent Assembly who basically signed this document, that is Rajendra Prasad, and therefore it was not submitted for the signature of the Queen, or it was not brought before the British Parliament, and therefore one finds a radical break here, that India was not a dominion state, like Pakistan, which continued to be a dominion state for quite some time, I think perhaps till 1955. But India, from 1947 itself, after this Independence Act was passed, and particularly after 26 November 1949, when basically this entire thing was done, finished. And when it was enforced on 26 January 1950, India became a sovereign country, that basically its association with British Commonwealth completely broke. But one thing to be borne in mind, that India remained a member of Commonwealth, but of course the terms were different. It was a sovereign country, sovereign nation, voluntarily, willingly becoming part of this free association. It was a voluntary association. It was not compulsion, but it was its willingness to be part of it, because India shared with many countries many things and therefore wanted to continue with this. So, this sovereign therefore had a meaning, that India declared itself to be sovereign, not a dominion state, but rather a sovereign country, having no obligation towards anyone. So, external and internal sovereignty both were asserted, and therefore it was a political statement, it was a philosophical statement, and therefore this word sovereign is very important. Now, we the people, that is something quite significant today. We the people solemnly resolve. Now, who are this we the people? I mean, therefore, the recent debate which has started among many scholars, that this term people come before any institution or any principle which basically gives a basis for this representative democracy, that is parliamentary democracy. Therefore, who is supreme? The people, their will, I mean the general will of the people, the sovereignty of the people, that is supreme, or the will of the parliament, or the will of the people as channelized through parliament, that is supreme. And this debate is, now this issue is acquiring new significance today, when we find that in name of civil society activities and civil society churning, a lot of things are happening which have started demanding now that these people and their general will should have more say in the governance of the society and in the basically framing of the policies than it is done. This will of the people basically now is only taken into account through elections after 5 years, but that is not enough. From time to time, all important decisions should be reverted back to the people for their opinion. Rather, in fact, what they would argue, that some sort of referendum and initiative kind of instruments and mechanism could be used to solicit the opinion of the people. So, this is the position, that India of course has gone for a representative democracy, but one should not forget that this term, the general will, the will of the people, the sovereignty of the people comes before everything else, that is in the preamble itself. So, therefore, this is one important philosophy which is open for debate, because a lot of people would say that this is not true, that we the people is there, but this will of the people without procedures, without procedural basically linkages will have disastrous consequences for a society like India. So, the will of the people is there, and that will basically is secured or basically channelized through periodic regular elections, and people speak their mind through elections, and therefore that will also expresses itself, and once that expression is done, then the representatives are the true custodian of that will. So, basically this old delegate and the trustee debate in representation in political theory, to some extent one can find a glimpse of this here also. But what I am trying to say, that this issue, this philosophy of the constitution, one also is trying today to find in this usage the term we the people, which precedes the other usages like parliament, parliamentary procedures and so on, parliamentary form of government and so on and so forth. Now, related to this is democracy. As I mentioned, the democracy, the term, many people felt that was not there in the text, but in fact it was defended, that whether we use this term, whether you include this term or not, but nonetheless democracy is the essential feature of this entire constitution. So, therefore, today this democracy, what is the nature of democracy? What is basically a character of this democracy? These things are debated today, and as it is well known that democracy of course is a very ambiguous term. Democracy can have number of forms. Even the system of government, a democratic system of government can have many forms. The two important forms of course are parliamentary system and the presidential system. Now, of course, what India has done, that India has combined many features of the two, but we will come to this issue later. Now, this form of government is also important. Now, Ambedkar himself, when he was moving this draft constitution, he said that any student of constitutional law, when he basically comes to this business, will have to confront two questions. First, what is the form of government and what is the form of constitution? And then he said that so far this form of government is concerned in this constitution, that is the draft constitution which he was piloting. He said this is a parliamentary system of government. And then he explained that why India had gone for a parliamentary system of government. He said that there are two types in the world, one which gives more importance to stability and another which gives more importance to accountability and responsibility. And he said that India perhaps decided to go for a system where you have more responsibility and accountability than stability, and therefore we have gone for this parliamentary form of government. He said that of course with the present development of this science of government, or the this art, or one can say with this knowledge of constitution, there is no system which can combine both in the same measure, stability and accountability. India has settled for accountability. And then he said that why this is more accountable, and then he added that what happens, that parliamentary system is based on a principle of accountability in which there are two types of auditing. One is the periodic auditing, another is the daily auditing. The periodic auditing takes place through periodic elections, and daily auditing takes place on the floor of the parliament, when the members have this right to grill the government, to ask questions, to ask supplementary questions, to use number of mechanisms which are available with them to basically censor the government, to dislodge the government, and so on and so forth. So therefore, this daily auditing is also quite effective. So therefore, it is more accountable, unlike the presidential system where you have only periodic auditing during elections. It is a different matter today that a lot of people have started asking that how effective is this daily auditing and periodic auditing. Periodic auditing is perhaps still in a much better shape, but daily auditing, which basically parliamentary interruptions of the parliament and the members not discharging their duties effectively, and the debate on decline of parliament, these things have started now coming to the fore when people are discussing these issues. But nonetheless, we also remember that this was the defense of Ambedkar so far as going for this parliamentary form of government is concerned, because this philosophy had this meaning, that it was largely required for creating an accountable system, because Indian society, he also added, perhaps that was not known for its accountability. It was a hierarchical society. There was no democratic culture, in a different context, in a different speech. He said that basically democratic culture is something which is not basically there from the very beginning. It has to be cultivated, and India lacks that culture, and how to cultivate that culture is on the people. So therefore, all these shortcomings basically force this Constituent Assembly to go for a particular type of government, which they believed that would be more appropriate for the people. So therefore, this form of government. Now another question is the form of constitution, which a student of constitutional law has to confront. Now this form of constitution, he said that India is a federal constitution, and there is no dispute on this. And then he said that of course, lot of criticisms are there, that Indian constitution is basically talks of federalism, but half-heartedly, where the center has more powers, where you have provisions like emergency, which basically suspend the entire constitution. The entire administration of the units is taken over, where you have encroachment on the states' rights, where the states have no autonomy, where basically a state's existence is at the mercy of the center, because the creation of a state is basically in the hands of the parliament. So all these issues and all these criticisms were there, but still he said that India has gone for a federal system, of course based on its own requirements, and therefore it has modified many principles to suit its requirement. Even the term union, why the federal is not used, why the union has been used, he also defended it. So India is a union because it is an indestructible union, and therefore the moment we say federal, then basically it becomes a destructible union. But here it is indestructible union. That union is not the voluntary agreements among the various units, rather they have come together because of number of factors. So all these things he defended. Now coming to this Another issue, I mean, which figures in the preamble, the republic. Now, republic is also something very significant to remember. Now, of course, people often get confused in a republic and democracy, but democracy can exist without a republican form of government, as well as a republican form of government can exist without democracy. So, there is no such compulsive this thing relationship between the two. Now, India has gone for a republican form of government. That means the head of the state is elected by the people, and therefore, this was an important philosophical commitment. This was an important philosophical orientation of the people, and of course, the constitution making body. Therefore, this preamble had to accommodate this word. Of course, we hear about many important ancient republics in India, but those republics had a different type of democratic order, even if that was a democracy at all. So, therefore, what happened, a republic is not a new word for India, because we have had examples when we had elected kings or elected leaders even in ancient time. But in modern times, we try to basically import this thing, or rather not import, but rather we can say that in a modern times we try to incorporate this important principle through which people's supremacy could be established. So, therefore, this word republican. Now, coming to the two important terms which have been inserted in the constitution, secular and socialist, and both have come in the constitution, and the preamble of the constitution after 42nd amendment brought them there. Now, of course, the 42nd amendment had a political meaning, because it was basically an amendment which was enacted during emergency. So, many people have basically have questioned it, that why these two words were inserted, but one thing to be remembered, that subsequently when Janata Party government came into power, it basically reversed many important things in the constitution which were brought by 42nd amendment, but these two words were left untouched. Now, again people have started debating it, but nonetheless one thing we should remember, that whether the terms secularism and socialism were used in the preamble or not, they are essential. There are many principles in the constitution which basically tell you about 2-3 things. Secularism, of course, implies number of things, but 2-3 important principles are always highlighted. One is basically non-discrimination on basis of identities, on creed or anything. Number 2, it is also freedom of religion, and third, it is basically a disestablishment, that there is no relationship between a state and any religion or religious organization or religious body. So, therefore, these 3 principles are basically the basis of modern secularism, and we find that even if this term did not figure in the preamble, but these 3 principles were very much there in the text of the constitution. In the fundamental rights itself, all 3 of them find their place. If you look at 15 and 16, Article 15 and 16, if you look at Article 25, if you look at some other articles which completely create a disestablishment here, no relationship between religion and the state. So, therefore, these principles were the important principles, the philosophy of the constitution. So, therefore, what perhaps 42nd amendment did only by bringing it in the preamble of the constitution made a statement that secularism is one of the philosophical foundation of India's constitution. So is the case with socialism. Of course, it is more ideological, and it is of course ideological like any other thing, but nonetheless redistribution, in fact, egalitarian creation of egalitarian society, a number of things for which socialism is known for. In fact, those principles we find in the constitution itself. So, therefore, there is nothing surprising that when 42nd amendment brought socialism, of course, the socialism from the very beginning was a contentious issue, and that is why I said that when Ambedkar had to defend it, he said that constitution is a political statement. Constitution talks about form of government, form of constitution and other things. Constitution does not tell you about the future form of society or economic system which a country will go for. Rather, making such thing part of the constitution will be rather binding the future generation with a particular system which would not be proper. Therefore, he turned on this basically request that socialism should be inserted in the constitution. Now, if you look at the preamble, then there are few other things which are equally important. Justice, liberty, equality, these three things along with fraternity. And therefore, these four terms which are to some extent in modern times are associated with French Revolution, but nonetheless have had number of articulations in different parts of the world including India. They are significant. Now, in India, for example, even if we start justice, now justice, the preamble itself commits itself to three different types of justice: social, political and economic. All three types of justice is basically is promised. So, basically political justice, that there is no discrimination, economic justice and social justice, which is perhaps a very important theme today, that social justice it promises. Of course, social justice in Indian constitution has a particular meaning, because normally it is believed that in India there is only two types of justice in the text of the constitution. One is distributive justice, another is social justice. But I will argue that there is a third variant also, and that is basically repartitive justice. So, you have distributive justice, you have social justice and repartitive justice. Of course, the time does not allow me to go into details that how this tripartite bifurcation, trifurcation of this thing has been done in Indian constitution. So, each according to his ability, that is a distributive, each according to his need, that is social, each according to his damage, that is basically the social. So, I mean this repartitive. So, all these three principles of justice are there. Now, what happens that this justice is there along with this principle of non-discrimination, that is secularism. So, secularism and social justice both have been used in the same breath, particularly in the fundamental rights chapter, article 15 and 16, and therefore, it is quite significant that you have on the one hand non-discrimination, as on the other hand you have the positive discrimination, that you have to have a positive discrimination for certain people, the oppressed people, the needy people, the disadvantaged people, and even if that measure is taken by the state, it cannot be called discriminatory, because they are given only helping hand by the state to bring them at par with those who are more privileged. So, this is basically the discourse of justice. Similarly, on liberty, freedom, I mean there is an elaborate discussion. Of course, it is also criticized that there are a lot of riders, there are a lot of constants, but of course, freedom was very dear, because Indians had lost this freedom at the hands of colonial rulers, and therefore, this freedom they wanted to protect and keep secured. So, therefore, that is also important thing. Fraternity is another important thing which Ambedkar also emphasized in his speeches, and he believed that fraternity was very important. Now, tolerance of course is one aspect of this fraternity. Now, secularism is one political form through which it is expressed, but this fraternity is very important feature of any democratic order, and these things occur in the text of the constitution, they occur in basically the preamble of the constitution. Now, what happens that this global world peace and other things are another philosophical dimension of Indian constitution. For example, you have this now the new section called duties, you have this directive principles of a state policy, and there are many other things which basically supplement this philosophical statement which we find in the preamble of the constitution. So, rights and duties both existing there. Of course, duties also have come later, but rights and then directive principles of a state policy. So, basically you have political rights and then have socio-economic rights. We can make a distinction like this. Fundamental rights are political rights, broadly political rights in nature, but not only political rights. You have cultural social rights. You have basically rights, identity rights. For example, article 29 and 30, and that is another uniqueness. This is another philosophical thing. The minorities, because democracy is normally considered to be a rule of the majority. But in India, what happened that minority interests were kept in mind, and one of the philosophy of Indian constitution is that how to basically secure the minority interests and minority rights, and therefore, India was ahead of its time. This minority discourse emerged much later. Of course, it had emerged in 20th century after First World War, but one of the important dimension of this Wilson's 14 points was right to self-determination. But in India, what we find that what has emerged in political theory much later is multiculturalism and communitarianism. These things were basically kept in mind, and therefore, in India we find the constitution that one of the philosophical statement it makes is how to harmonize the interest of the majority and interest of the minority, how the cultural identity concerns and the rights of the minorities have to be protected. So, therefore, this is another important aspect we find in Indian constitution. Now, what happened that even on federalism we find, even the form of government we find that it is not only two tier, that is the center and the states, but rather it has tried to go for a multi-level federalism, and that is why this directive principles of a state policy talks about this local bodies, local self-government, the different level, the self-government and the shared government. If federalism stands for shared government, then local self-government stands for self-government. So, it has tried to combine the philosophy of the two, the shared government and the self-government, that only through this that people's interests could be protected. Now, even in terms of a number of other features, one finds that what has happened that India has combined judicial review with little bit of parliamentary sovereignty, or one can say the separation of power. Parliament is neither sovereign like Britain, nor judiciary is as powerful as United States of America. Of course, gradually judiciary has been showing lot of inclination to move in that direction, but there is a constitutional text. So, who is sovereign? This philosophical issue keeps coming up, and therefore, in Indian context it is often argued that neither parliament is sovereign nor judiciary is sovereign. What is sovereign is the text of the constitution. So, you have the constitutional supremacy, neither the supremacy to parliament nor the supremacy to legislature. So, therefore, we find a lot of philosophical statements, lot of philosophical positions emerging from this constitution, and they are of course a matter of interpretation. India's Supreme Court has been interpreting these issues, India's parliament has been interpreting these issues, civil society is today interpreting these issues, and of course, the academia and the social science have from the very beginning have been interpreting these issues, but I think that nonetheless we can still figure out certain philosophical foundations of this constitution.
Thank you so much, sir, for this very interesting presentation and something very integral, and of course I think even a general reader would like to talk about the Indian constitution and to learn its basic features and it's the philosophy with which it was made. So, thank you so much, sir, for being here today and talking to us, and again thank you viewers, have a wonderful evening ahead. Thank you.